Your access code was...
Lauren,
It moves fast. Give me 1 second.
Can you hear us now?
they're looking
Yes,
for it.
now we can hear you.
Yep, there we go. Say something, Mr. Scarpelli. Nope.
Mrs. Clarfelli?
Oh, no. You had it in the beginning, Lauren.
I don't know
You
why.
had it in the beginning.
I'm not
Yes. Yes, we can hear you now. Can you hear us? Nope. All right. They're checking their emails.
I don't see Mr. Clinesmith. Is he there?
No, he's actually with other counsel. They're trying to log in right now.
Okay. Mr. Scarpelli, I see you. Ma'am, I'm sorry, what's your name?
They're trying to log in so that you can see them. They can see everyone.
Mrs. Scarpelli? I can hear him brief a little bit. Mrs. Scarpelli, can you hear me? I'm not hearing him.
You reached Nicole Belmore in the United States District Court for the District of Columbia.
That's me. I'm not at my desk.
Working. Please contact me via email at Nicole.
Counsel?
Lisa. Can you hear me, Lisa?
Yes, I can.
Lauren, you can't hear anybody?
Nicole, we can hear you. You're being heard.
We can hear each other, and that's it. The three of us.
Oh, we can't hear them.
Okay, here's the judge.
All right, good afternoon,
Judge, good afternoon, Judge. This is Lauren. We're having some technical difficulties with the government and for the defendant and other co-counsel connecting. So if you can give us 1 second.
Yeah. You appear on the screen.
Mr. Scarpelli, can you hear us at this time? I can hear them speaking. Mr. Scarpelli?
Mr. Scarpelli, do you see well, I guess he can't. Let me email him, Lauren. Let me email him. I think his button is on mute.
It's not because I can hear them currently speaking. Ms. Church, have you had any success getting your client on the line?
I have, Your Honor. They were able to log in. I was not able to see them on the screen, so that I believe that they're trying to log in again. They could see and hear everyone, but I don't think we could see or hear them. They're trying again.
So one thing people can do is if you just refresh the link, just refresh the page, that often cures problems with not being able to see or hear people.
Okay.
Also, make sure that he's using Google Chrome to connect.
I will make sure they're doing that as well.
Can you hear us?
Yes,
Yes.
we can hear you.
Great.
Thank you. Mr. Scarpelli, who's with you?
Good afternoon. It's Anthony Scarpelli, and it's Niraj Patel, who's a Special Assistant United States Attorney for the District of Columbia, and Department of Justice Investigator Timothy Furman, Fuhraman.
Mr. Patel, can you spell your first name for me, please?
Sure, it's Neeraj.
Thank you.
They are loading right now. They were switching over devices, so to hopefully have more success. They just received an error message. The joining meeting failed. We'll try again.
You guys hear me?
Yes.
Okay. I just sent the email with the dial-in information for the defendant if he cannot do it by video.
They're going to try and dial in while simultaneously getting the video to work for whatever reason. They're keep getting an error message. Ms. Elmore, the defendant has dialed into the line. The host has not arrived.
I know, she's connecting now. She is,
Thank you.
connected. Thank you. Welcome to To join the conference, please your host password was not recognized. Please enter the security code. There are 3 participants on the call, including you. You are joining your conference as the host. For a menu of available commands, press *#.
Counsel, can you hear us? Mr. Clinesmith, are you able to hear us?
Yes, this is Justin Schur and Emily Damroff from Mull Lampkin, and Mr. Clinesmith is here as well. We apologize for we're having some IT issues on our end, so I apologize for the delay and our inability to access the video conference.
Okay, this is Judge Boasberg. Thank you. I'm sorry that you couldn't do that either. So I guess the first question then, Mr. Schur, is are you and your client prepared to go forward today with a plea, even if it's now by audio rather than video?
Yes, Judge.
And Mr. Clinesmith, you understand you have the right to have your plea taken in person, but given the pandemic, we're holding, for now anyway, because we've suspended all in-court proceedings, we are holding these by video and audio. You do have the right to wait until we begin in-person court proceedings and have your plea taken then, or we can go forward today. What's your preference, Mr. Clinesmith?
I am fine with today, sir.
Okay. I'm sorry, we probably should have called the case. So, Lauren, why don't you call the case now and we'll continue.
Your Honor, we're on the record for criminal case 20-165, United States of America versus Kevin Clinesmith. Counsel, please identify yourselves for the record.
Good afternoon, Your Honor. Anthony Scarpelli, Assistant United States Attorney for the District of Columbia, along with Niraj Patel, who's a Special Assistant United States Attorney for the District of Columbia, and also with us is Department of Justice Investigator Timothy Furman.
Okay. Good afternoon to all of you.
Good afternoon, Your Honor. Justin Schur, Megan Church, and Emily Damroff from Mr. Clinesmith.
All right. Good afternoon, and again, good afternoon, Mr. Clinesmith. So I think the first thing we need to do is arraign Mr. Clinesmith, and then I want to mention a couple of preliminary issues.
Your Honor, let the record reflect that the defendant, Kevin Clinesmith, has been provided a copy of the criminal information. Mr. Clinesmith, you are hereby charged in criminal case number 20-165 with 1 count of false statements under 18 U.S.C. 1001, small letter A, 3. Do you wish to waive the formal remit of information?
Yes, I do.
Okay. For the purposes of the portion of this proceeding, how do you wish to plead?
Guilty.
Okay, so let me mention a few threshold questions. I know this case has certainly generated a lot of media and public attention, and counsel made points. I think it's important to put these on the record. The first is, as many of you know, I am currently the presiding judge of the Foreign Intelligence Surveillance Court, or FISC, FISC. This case involves false statements in relation to a FISA application and 3 renewals. The case, however, is a criminal case. It is not a FISC case, and it is a case that was randomly assigned to me. In other words, like any criminal case, be it an indictment or an information, it's placed on in the random wheel which spins and lands on a particular judge, and this one happened to land on me. So the fact that I am on the FISC or that I am its presiding judge had nothing whatsoever to do with the assignment of the criminal case to my criminal district court docket. The second is that I fully believe that my role on the FISC and as its presiding judge does not preclude my fairly presiding over this case. Now, while I did not sign any of the 4 applications that are at issue here, I could see that the FISC itself could be perceived as a victim of false statements. And as I said, I am the presiding judge of the FISC and therefore represent its interests. So to ensure that this didn't make either side uncomfortable with my presiding over this criminal case, and I think particularly the defense would have reason to have some facial concern about this, I had my chambers reach out to counsel on Monday to advise them that I would be raising this potential recusal issue at the outset of today's hearing. And I had my chambers inform counsel that either side could move for my recusal at the outset of this hearing, and that I would not require argument, and that I would be happy to recuse with no further questions asked. So I enabled each side to have 2 days to consider their positions, and so I'll turn to that now. Mr. Scarpelli, does the government wish me to recuse from presiding over this case?
No, Your Honor.
No, Your Honor.
Thank you, Mr. Schur. Does the defense wish me to recuse from presiding over this case?
No, Your Honor.
No, Your Honor.
Does either side have any questions as to my involvement in this matter, in the FISC, or my FISC role as it relates to this case, Mr. Scarpelli?
The government does not, Your Honor.
Mr. Schur?
No questions from the defense judge.
Okay. All right. Is the government prepared to proceed with the plea today?
Yes, Your Honor.
Yes, Your Honor. Is the defense?
Yes, Judge.
Okay. Then I'm going to have the court of deputies swear Mr. Clinesmith in before we proceed.
Judge, can I just make sure all the parties, make sure if they have the computer and the phone, to mute the phone so we take away that echo?
Good.
If at all possible, take it off speakerphone if you can.
Obviously, if you're not on the computer, some defense counsel then shouldn't mute the phone, but if you are on the computer, then you should mute the phone. Thank you. Okay, go ahead with the swearing in of the defendant.
All right, Mr. Robert. Oh, I'm sorry. Go ahead, Lauren.
Mr. Clinesmith, I'm going to ask you to raise your right hand, but we do understand that you're by telephone. Do you solemnly affirm and truly declare that you well and truly answer all questions propounded to you by this court, and this you do under the pain and penalty of perjury?
I do.
Okay, please state your full name for the record.
Kevin Eugene Clinesmith.
Thank you.
All right, Mr. Clinesmith, if you'd be so kind as to keep your voice up, just so we can make sure to hear you and so the court reporter can. All right, because I placed you under oath, if you answer any of these questions falsely, you could be prosecuted for perjury or false statement. Do you understand?
I do.
Okay, tell me your date of birth.
May 18th, 1982.
And how far did you go in school?
I have a master's of law.
Have you taken any drugs or anything else in the last 2 days that might make it difficult to follow these court proceedings?
No, Your Honor.
Were you born in the United States?
Yes, Your Honor.
Does either counsel have any question as to defendant's competence to enter the plea today, Mr. Scarpelli?
No, Your Honor.
Mr. Schur?
No, Judge.
Okay, given those representations, I find the defendant is fully competent and capable of entering the plea today. Now, Mr. Clinesmith, you should have before you a plea agreement which is 10 pages long. Do you in fact have that?
Yes, Your Honor.
And the 10th page appears to bear your signature. Is that in fact your signature?
Yes, it is my signature, Your Honor.
Did you read and understand this agreement before you signed it?
Yes, Your Honor.
Is this the agreement you wish to enter into today?
Yes, Your Honor.
Okay, I'm going to go over the agreement. I'm not going to hit on every term. I'm going to go over some of the non-sentencing terms and then the sentencing terms. And I just want to make sure you understand that as long as a term is in the plea agreement, just because I don't mention it, you are still bound by that term. You understand that?
I do, Your Honor.
But you understand that you're pleading guilty to a criminal information under which you've just been arraigned, and it charges you with one count of false statements in violation of 18 U.S.C. Section 1001A3. You understand that?
Yes, Your Honor.
Now, in exchange for your plea of guilty, the government agrees that it will not prosecute you further criminally for any of the conduct you committed that is set forth in the statement of offense, which is the second document you should have in front of you. So first, you also have that document.
Yes, Your Honor.
And do you understand that the government will not prosecute you for any other, with any other charges based on any of the conduct in that statement of offense?
Yes, Your Honor.
Now, the government has also agreed not to seek a change in your release conditions pending sentencing. In other words, many people between the time of their plea and sentencing are actually detained in jail, and the government here is not going to be asking for you to be detained, although the final decision of your detention rests with me. Do you understand that?
Yes, I do, Your Honor.
Okay, let's talk about sentencing now for a minute. You understand that the maximum penalty for this charge is 5 years in jail, a fine of $250,000, a term of supervised release of up to 3 years, and a $500 special assessment, as well as any fine or interest on such fine that I so ordered.
Yes, Your Honor.
Now, you had a chance to talk with your lawyers about the United States sentencing guidelines.
Yes, Your Honor.
And under those guidelines, there is a grid which sets forth along one axis the base offense level, and on the other, the criminal history conduct. And where those two axes intersect is the box that sets forth your applicable sentencing range. Do you understand that?
Yes, Your Honor.
Now, in this case, there is an exception I'm going to mention. Is that let me say it this way, that your offense level is either 4 or 6, depending on whether the government seeks a 2-level enhancement for abuse of position of trust. And your criminal history category is 1, which is the lowest category because you have zero criminal history points. And under either level 6 or level 4, your sentencing guideline range is 0 months to 6 months. Do you understand that?
Yes, Your Honor.
Now, do you understand that I'm not required, I have to start with the sentencing guideline range of 0 to 6 months, but I'm not bound by that range, and I could sentence you above that range to any amount of time up to the statutory maximum. Do you understand that?
Yes, Your Honor.
And has anybody told you the sentence I'm going to give you in this case?
No, Your Honor.
And they couldn't, because the only one who knows is me, and I don't know until I've reviewed all the material in connection with sentencing. All right, let's talk now about the statement of offense, which is the other document that I mentioned earlier, and that document is 8 pages long and also appears to bear your signature on page 8. Is that in fact your signature?
Yes, it is, Your Honor.
Did you read and understand this document before you signed it?
I did, Your Honor.
This document actually sets forth the facts that the government contend occurred here. In other words, the acts that you actually committed. And do you agree that what the government sets forth here is in fact true?
Yes, Your Honor.
And most specifically, that on page 6, that you intentionally altered an email to add the language and not a source in regard to individual 1, and you knew that such statement was not in fact true. Mr. Scheer, I'm not sure if you're conferring with your client, but I didn't hear a response to that question.
Yes, Judge, I apologize. We just put the line on mute for a second. And Mr. Clinesmith is prepared to answer the question.
Sir,
Okay, so
Sir, at the time, I believe that the information I was providing in the email was accurate, but I am agreeing that the information I inserted into the email was not originally there, and that I inserted that information.
So in other words, did you agree that you intentionally altered the email to include information that was not originally in the email?
Yes, Your Honor.
All right, so have you had enough time here to talk with your lawyers, and are you satisfied with their services?
Yes, Your Honor.
But I want to talk about the rights you're giving up by agreeing to plead guilty. You understand you're not required to plead guilty, and you do have the right to go to trial on this charge if you wanted to.
Yes, Your Honor.
If you decided to go to trial, you have the right to have your lawyer with you, and lawyers with you, and they could make motions, make objections, and cross-examine government witnesses. You understand that?
Yes, Your Honor.
The government would have the burden of proving you guilty beyond a reasonable doubt, and they would have to convince 12 jurors to unanimously convict you. You understand that?
Yes, Your Honor.
Now, if you went to trial, you would have the opportunity to present evidence. And that means you could put witnesses on a witness stand, or your lawyer could put witnesses on a witness stand and submit documentary and other types of evidence. But if you decided not to introduce any evidence, I would tell the jury they couldn't hold that against you because the burden of proof would be entirely on the government and you would be presumed innocent. You understand that?
Yes, Your Honor.
In addition, if you went to trial, you have the right to testify on your own behalf. And if you chose not to do so, I would tell the jury they could not bet against you because you would have an absolute right to remain silent and not to incriminate yourself. Do you understand that?
Yes, Your Honor.
Now, if you went to trial and were convicted, you would have the right to appeal. If you couldn't afford an attorney, I would appoint one for you. Do you understand that?
Yes, Your Honor.
But if you if you take this plea today, there will be no trial and there will be no appeal, except in a couple of circumstances I'm about to mention. Do you understand?
I do.
The only circumstances in which you could appeal are if I sentenced you outside of the sentencing guidelines, if you claimed you received ineffective assistance from your lawyers, or if you discovered new and previously undiscoverable information that was material. You understand? Otherwise, you will have no right to appeal.
I understand, Your Honor.
You also understand if I accept your plea, you may be deprived of valuable civil rights, including the right to vote and the right to hold certain jobs, the right to serve on a jury, and the right to possess any firearm.
I do, Your Honor.
Has anybody forced you or threatened you to get you to plead guilty?
No, Your Honor.
Do you have any questions as to the rights you're giving up or anything else in connection with this guilty plea?
No, Your Honor.
How do you plead then to the charge of false statements, guilty or not guilty?
Guilty, Your Honor.
Satisfied the defendant has entered a knowing and voluntary plea and there's a factual basis for such plea. I therefore will accept the plea and find him guilty of one count of false statements. Is there anything, before we set a sentencing date, anything else in connection with a plea that the government wishes me to inquire about?
No, Your Honor.
Anything else, Mr. Schur, that you wish me to inquire about?
No, Your Honor.
Okay, so let's set a sentencing date. The last plea I took last week, I set a date for November 10th, so I'm happy to set a date the following week, or if counsel prefer a different timetable, that's fine, but that's the timetable I'm working on right now, Mr. Scarpelli.
Your Honor, the parties had spoken before this hearing, and we were going to see if December 9th, 10th, 11th worked for the court, or December 16th, 17th, or 18th.
Yeah, I've got a bench trial that I've got on the 9th, but I could do the 10th or 11th, whichever you prefer, whichever counsel prefer. Mr. Scarpelli, do you have a preference?
We do not.
Mr. Schur?
No preference, Judge.
All right, let's say December 10th at 11 a.m. for sentencing. I would ask that the pretrial memorandum be submitted a week in advance. And Mr. Scarpelli, if the government is seeking a two-level enhancement, then I'd ask that you submit such brief 3 weeks in advance of trial, and that Mr. Schur, you can then respond 1 week, 3 weeks in advance of sentencing, and Mr. Schur, you can respond 1 week in advance of sentencing. Otherwise, pre-sentencing memorandum may be submitted 1 week.
Understood.
All right. Any thing the government wishes to raise regarding conditions?
Yes, Your Honor. With respect to release conditions, in light of the fact that the defendant has known about this matter for quite some time and hasn't fled, we do not oppose his release conditions remaining that he's on pretrial release. We would ask additionally that he surrender his passport and not obtain any foreign travel documents. And with respect to travel within the United States, his travel will be limited to Washington, D.C., Maryland, Virginia, Ohio, Michigan, and West Virginia. But he may travel to other locations within the United States with prior approval from the government. It will give us at least 3 days advance notice. Additionally, he will also provide the government his travel itinerary with dates of travel and where he will stay for travel anywhere outside of the D.C., Maryland, Virginia area.
Okay. Mr. Scher, any objections to any of those provisions?
No objection, Your Honor.
Okay. I will then follow the government's recommendation and require that Mr. Clinesmith abide by those travel restrictions and surrender his passport. I will also follow the government's recommendation that he remain on his personal recognizance pending sentencing, which is also part of the plea agreement to which the government was a party. Mr. Clinesmith, do you understand those restrictions?
I do, Your Honor.
Okay. Anything else either side wants to raise before we conclude these proceedings, Mr. Scarpelli?
Your Honor, I would just ask the court, we had provided the court the waiver of trial by jury and a waiver of indictment, and the court, at its convenience, signs those documents.
Yes, I will do that. I will actually, as to those documents, Mr. Clinesmith, you understand that we've already talked about your jury rights. There's also a document here called waiver of indictment. And as I'm sure your lawyers have explained to you, what that means is that the government in this case is proceeding by information rather than indictment. In other words, you agreed as part of this plea that the government need not seek an indictment by probable cause from a majority of grand jurors, but which is every person charged with a felony's right, but that instead they proceed by way of information, simply a charging document that they sign. Is that the waiver you wish to enter into in regard to your indictment?
Yes, Your Honor.
Okay. Thank you. I will sign those documents. Mr. Scher, anything further?
Nothing further, Judge.
Okay. Thank you all. We'll see you in December.
Thank you, Your Honor.
Thank you, Judge.